right, good afternoon. It's a little after 5:20. This is the House Judiciary Committee. We've got voting list number 6. We're going to start, actually, go backwards here. We're going to start with House Bill 1190, which is actually Lauren, but I think you should stay. This came out of the Family Law Subcommittee. I don't believe that there were any amendments. Is that correct? All right. There's a motion for a favorable and a second. Any discussion on House Bill 1190? Did you say sponsor issue? Well, the courts, I can understand that. It's a judicial conference bill. I do appreciate your comments, Delegate Card. But I do appreciate sometimes the judges as well. All right, so it's the 15th. We have a favorable and a second. Any further discussion? 1190, we're starting at the back and going to the front. Seeing none. The Vice Chair. Yes. Yes. Munoz. Yes. Yes. Crutchfield. Yes. Yes. Cardin. Yes. Yes. Bartlett. Yes. Yes. Embry. Yes. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons is excused. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. Motion is adopted. 21. Okay. You all should have amendments for 1071. 1071 is the bill that has to do with police being able or not being able to stop someone upon their detecting the odor of cannabis. And so what I'm going to ask is I'll ask counsel to just describe what the amendments to the bill do, please.
Hello? Okay. So the amendments change the penalties, the maximum penalties for
1071?
yes.
Okay, I'm sorry, that's right. Yes, got it.
Smoking, it adds, the amendments add on the prohibition against smoking of cannabis in a public place and changes the maximum penalties.
Yes. Sure.
Thank you.
So there was an amendment done to the bill, and I think it was it was on the first page, at least, of the reprint. It talks about last year the House passed a fine for the smoking of cannabis in a public place that was $50 for a first offense and $150 for a subsequent offense. The Senate, at the last minute, changed it to $250 for a first offense and $500 for a second offense. That's on the first page, and we changed that back to $50 and $150 as the House passed it last year. Then it does further, and I'll hand it back to Claire to talk about the remainder of the. You're still live.
And then the amendments just strike the original language of the bill and rewrite the prohibition against a law enforcement officer initiating a stop or a search of a person, a motor vehicle, or a vessel based solely on one or more of the following: the odor of burnt or unburnt cannabis, the possession or suspicion of possession of cannabis that does not exceed the personal use amount, or the presence of cash or currency in proximity to cannabis without other indicia of an intent to distribute. And then it goes on to say that if a law enforcement officer is investigating a person solely for driving or attempting to drive a motor vehicle or vessel while impaired or under the influence of cannabis, the law enforcement officer may not conduct a search of an area of a motor vehicle or vessel that is not readily accessible to the driver or operator of the motor vehicle or vessel, or reasonably likely to contain evidence relevant to the condition of the driver or operator of the motor vehicle or vessel. And then there's a uncodified section that says that the exclusionary rule and its exceptions, as judicially determined, applies to this act. The last two sections just deal with the effective date, and there is one technical correction to the reprint that was sent out. On the very last line, Section 5, and be it further enacted that except as provided, it should say in Section 4 of this act, not 3.
Could I have a motion on the amendment?
I move favorable.
There's a motion for amendment, favorable on the amendment and a second. Now we'll take questions on the amendment, effectively the amended bill. Delegate Conaway? Yes, we'll do that because it effectively, that's what the amendment does.
Thank you. Thank you, Mr. Chairman. So this is, you can't smoke the cannabis or you can't smoke the cannabis in a public place, is that right?
That was what was passed as part of last year's cannabis bill, and that would remain. The difference, what this bill changes is the fine from $250 for a first offense and $500 for a second offense to $50 and $150, which is what the House passed last year. So it returns the fines to what we passed from last year.
So this is just dealing with the fine?
This is only dealing with the fines and only dealing with what we set the fines at in the bill that we passed last year.
Can I ask a general question,
Sure.
please? So when we say a public place, are we talking about a park?
It could be. There are still restrictions in some jurisdictions where people are allowed to smoke in parks and they're not in others. And in Baltimore City, for example, they prohibit smoking in some parks, and certainly in specific areas of parks. Baltimore City has set those rules.
Right.
And that's smoking in general, not necessarily just cannabis.
I didn't know that. And what about a smoke lounge? Because as I understand it, some places are going to open up smoke lounges. And
the Clean Indoor Air Act still applies. And that is under the bill, that was under last year's bill,
sir.
where the Clean Indoor Air Act still applies, but the Economic Matters Committee, and I was looking at somebody else, the Economic Matters Committee was dealing with issues related to consumption, indoor consumption sites. I don't think they took it up in the bill that was passed, but I'm looking, they did take it up in that? So that is in the bill that has already left the House.
okay,
those
and to
issues
tie
are-
it up and make it clean, that's why I was asking about the
Right,
fine.
so this
because
is
I didn't know
separate.
if they could go in and give this modified fine to people in the lounge. Thank you very much for
Okay.
explaining it to me.
Delegate Taylor,
Thank you, Mr. Chair.
could you lower the microphone so that,
Sure.
yes, that's fine.
I have a couple of questions, but I think I'm going to just point to Section B, I think it is, where it said part of the vehicle where you can't reach, what does that mean? Does that mean if the trunk, if you're sitting in the front, so you don't have to get out of the car in order, so can you just explain?
Section
The
B is a
reason-
reflection, I think the case is Taylor. The idea here, which oddly, okay, sorry,
Right.
was
Yeah,
not
nice.
aimed for you. Having said that,
This is your case.
it has to deal with where an officer can search and where they can't search if they find somebody who's driving under the influence of alcohol. So the idea is that what applies is the area inside the cabin of the car. It doesn't apply to the trunk. Because if you're going for impairment or seeking to prove somebody was driving impaired at that point, they aren't having a beer, putting it in the trunk, and then that you don't have that nexus to the driving impaired. So it doesn't cover the trunk. It does cover the passenger compartments of the car.
Okay, and then Is it okay for me to
Yeah.
ask another question? With regard to the public place, I guess just to follow up on Delegate Conaway's question, is this a subsection of maybe another section that says, that talks about if there is a no smoking in general, then cannabis also fits in that umbrella? Or is this something separate where potentially you could smoke a cigarette but could not smoke cannabis?
So what this is built off of is in last year's bill that dealt with the penalties for cannabis.
Oh.
We connected first the Clean Indoor Air Act. So anywhere that you cannot smoke marijuana, anywhere where you cannot smoke a cigarette, you also cannot smoke marijuana indoors. There apparently are going to be exceptions to that in consumption sites that were put into the bill that we passed, that the House of Delegates passed, that the Economic Matters Committee worked on related to cannabis. And so where you can't smoke indoors now, you can't smoke tobacco, you can't smoke cannabis. For outdoors, again, as I was pointing out with Delegate Conaway, the issue there is there are some places that don't let you smoke outdoors either. And those local jurisdictions set those requirements, and that would have to be dealt with on the local level as to whether they would allow marijuana to be smoked there or not. But it's in limited cases, and generally speaking, what I referred to, for example, Latrobe Park in my district, they can't smoke around the playground. So that's something that the city of Baltimore is going to have to figure out as to those specific add-ons. But that's what we did under the bill effectively last year. So all we're doing here is we're adjusting the fines down compared to what we passed last year with regard to that specific part of the bill.
Okay.
Delegate Young, then Delegate Conaway. And then I see Delegate Tolles.
Thank you, Mr. Chair. As you know, in our district and in yours, a lot of people don't have front yards, backyards. It's very, so if an individual who can't smoke in their home is prohibited, because of the situation in their home, wants to walk their dog and smoke, would they be prohibited under this public place definition?
I need to review again the definition of public place in this context, but we went through this last year, so the idea here was to just adjust the fines downward so that, I guess, should that be an issue, then that would carry a $50 fine as opposed to $250. But I think public place has a little bit of a different definition than that.
Yeah, I'm gonna leave it here because I know that's not the purpose of the amendment.
Yeah.
Just something to think about. Thank you.
Okay. Delegate Conaway.
Mr. Chairman, I just want to be made clear on this. Is smoking the same thing as vaping? Can vaping be considered smoking?
I am not familiar.
Wait a minute, Delegate Carden is answering.
Delegate Carden.
Thank you, Mr. Chair. I am not an expert on vaping. However, I did a little bit of research on this and found that because there's no incendiary or any actual burning of in the vaping device, it's just a heating up of vapor. It's not. It doesn't meet the definition of smoking.
So therefore, a person would be allowed to vape whatever they wanted to in the House of Delegates elevator. Is that correct?
I don't believe that vaping is allowed in.
No, it says no. The sign says no smoking. It doesn't say no vaping.
I would be surprised if there's not a specific prohibition against vaping.
Can we let the chairman finish?
No, I would be surprised if there's not a specific prohibition against vaping as well.
Really? Okay.
You may not say it on the sign, but I would be surprised if it's not.
So can you vape in a park in Baltimore City? I mean, I don't want my people to get in trouble for ignorance to the law, and since I don't know the law either, I figured I have to answer the question so I can write a letter about your answer. So can my people who live in the 40th district vape in the park. I think that's valid.
I think there's a distinction between vaping and smoking. That's what I believe.
Okay.
I don't know.
Thank you, Mr. Chairman.
Okay. Delegate Tolles.
Thank you, Mr. Chair. If you can allow me to just piggyback off something, Delegate Conway, wearing my former council member hat, at least for Prince George's County, if they have a sign up that say you can't do that, then it's prohibited. So usually businesses will say, put a sign up to say you can't smoke or vape or whatever that local jurisdiction, at least from what I've seen in my county. Yes. You're welcome.
On the amendment.
Mr. Chair, yes, thank you.
All right. On the amendment, do you have more on the amendment?
Yes.
Go ahead.
So I'm sorry, I got distracted. So, do you think, last year, I remember we had heavy discussion about the fines. Could it be likely that be adjusted in the Senate? Like last year?
I'm sorry, I refuse to try to predict the Senate anymore.
Fair enough.
I refuse.
Okay.
But
Just
thank you
wanted
for
to.
asking, but no.
You're welcome. Just wanted to stay
If
for
I
the
know
record.
more, I'll be sure to let you know. Further.
I won't hold my breath. Thank you.
Yes, Delegate Grammer.
Can you refresh us what the penalties are in comparison to consumption of alcohol? Because we changed that to a civil offense.
I believe that they were similar to that of an open container, but in some jurisdictions, open container contains it depended on the jurisdiction that you were in. Some still have a criminal penalty, some were just a fine.
I thought we removed the ability of local jurisdictions to have a criminal penalty.
On alcohol, I'd need to go back and take a look at that, but I remember from the debate last year that there was a distinction between those different counts.
All right, thank you.
All right. Delegate Tomlinson.
Thank you, Chair. So back to B, I think where we started, about if somebody is getting investigated for driving or attempting to drive a motor vehicle while impaired. So if the person is actually, if the investigation, I'm trying to think of the proper terminology, but if the investigation turns out that the police officer does think that the person is impaired, they're getting arrested, at that point, are they allowed to search the car?
So just to go through the language again, if a law enforcement officer is investigating a person solely for driving or attempting to drive a motor vehicle or vessel while impaired by or under the influence of cannabis in violation of 21902 of the transportation article, where that lives, or 8738 of the natural resources article, where driving while impaired, while driving a vessel while impaired lives.
Yeah.
The law enforcement officer may not conduct a search of an area of a motor vehicle that is not readily accessible in the rest. So you would have, the officer would make a stop. The officer would have to articulate or be able to articulate in court whether or not what indicia of bad driving they saw. If they had some other reason for pulling somebody over, they could potentially pull them over for speeding and pull them over, and they'd have to prove that the person was speeding. Then they'd go up to the car, make contact with the driver. If they found something that gave them effectively probable cause for driving under the influence, I believe that would come with further investigation. They would then have the ability to search in the car and only in the passenger compartment. And this would be consistent with what the law is already for a DUI for alcohol. So the idea is to make it parallel to what an officer effectively can do if they're investigating driving while impaired by alcohol, or driving while impaired by cannabis in this case.
Okay.
Right. Seeing no further questions on the amendment, all in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. All opposed? 1, 2, All right, the amendment is adopted. On the bill, there's a motion for a favorable and a second. Any further discussion? Seeing none. Delegate Schmidt.
Yeah, so two things I have here. So thank you, Chair. Delegate Simmons and I co-sponsored a bill here, House Bill 483, regarding vessel operation. So I see a lot of language here regarding vessels that hasn't really been discussed. Would it be possible to put a hold on this?
The bill that you're talking about with regard to, it was the subsequent offender for a vessel. So if somebody got a DUI for a vessel, or for driving a vessel, then that DUI would count towards the subsequent offender for driving a car under the influence, and vice versa. And that bill already, I believe that bill left here. We already voted for it, and the Senate
it did
passed
pass.
it too. Yeah. So this should not have. This has to do with what they can do if they're. This goes to a different issue. It goes to a substantially different.
Well, I guess my question would be, can I use a hold for this?
And your reason for the hold is for an amendment or for what purpose?
Well, I know there's a number of amendments that we reviewed today and a number of questions. And then I've also had people reach out to me regarding the state's attorney and also the sheriff as well. So I'd like to use the hold.
Okay, and what information do you need, further information do you need?
Well, I think a lot of it that we discussed was a little bit about the probable cause, and then obviously about the police work that they're using, for the investigative purposes. And there's still some loose ends on the cannabis idea and how that's going to proceed forward with it being legal. So I think that's where a lot of my questions lie.
So what I'll say is that the use of the hold is good for until the next voting session is called. Quite frankly, we're reaching that point of the session where I would be likely to call another voting session tonight.
Okay, I understand.
So it could be in an hour.
I understand.
So we can put a hold on this for an hour. We may still be voting on other things, but if there are issues that you want to raise regarding the legislation, that's fine.
Okay.
But I'm going to need to know what kind of an amendment you're looking for in the next hour, okay?
Sounds good. Thank you.
All right, thank you. We're going to go now then to yes. Delegate Tomlinson.
I thought that this was a part of the original bill, but apparently it was only part of the amendments. I don't know if it's still okay to ask a question.
Well, we're going to move on off that
Okay.
bill because,
All right.
yeah, we're going to keep going. So, yeah,
We were in the middle of a vote, so it will just come back to.
we're
we
going to
have a
be
motion
at
and
the point
second.
where we're in discussion, where we have a
Okay.
favorable and a second to that
Okay,
point.
great, thank you.
All right. So, and to be honest, we're at that point in the vote where effectively, we have a favorable and a second. We're in discussion. We had moved on from amendments. So at that point, if there are issues that people want to raise from other people, that's fine. You can raise them at that point. But we've moved past the point of amendments. So I'm not really sure that you're going to be able to do an amendment at that point. You can be able to talk about it. And if you want to get more information on the bill, that's fine. But we can go from there, right? All right, so let's go to House Bill 980. 980 is Delegate Young's bill. All right, and there are amendments here. Correct? We have amendments. And these have come from discussions, I think, with the Office of the Public Defender and others. Do you want to talk? I mean, I could read them or you could read them. It's up to you. I will go through the amendments. Let's do that. All right. So what the goal of the bill is to say if you're on parole or you're on probation or you're on pretrial, and actually you should do them in reverse, but okay. If you're on pretrial release, that a court can't revoke your pretrial or your parole or your probation unless the judge makes a specific finding at the time that they order pretrial release, makes a specific finding that the defendant's use of cannabis could create a danger to the defendant or others, and they include as a condition of pretrial release that the defendant may not use cannabis. That would also have to be done at the time of sentencing, when somebody's placed on probation, and the time that somebody is placed on parole. So the goal here is to say, we're not going to let you, unless the court explicitly says you are not allowed to use cannabis, and I find that using cannabis would create a danger to the defendant or others, that if they come back with a test later on that shows that they had smoked marijuana, that in and of itself wouldn't be enough to violate their probation, violate their pretrial, or violate their parole. Let me do this. Could I have a motion on the amendment? There's a motion on the amendment and a second. All right. On the amendments, any questions? Delegate Munoz.
See, both the judiciary and the state's attorney are against this bill. Does that alter in any way with the amendments?
I don't know whether it would necessarily alter the state's attorney or the judiciary's position on the bill. I think that I think the judiciary will probably argue, look, we get to set the conditions of pretrial and everything else, and you can't. It's not quite, not to make light of it, but it's a don't tell us what to do argument. Mm-hmm. And state's attorneys would want to be able to say, if somebody was still smoking marijuana, that was somehow something that should be used to violate somebody pretrial. I think what this comes down to is this is now going to be a legal substance. Mm-hmm. People are going to use it. If there's some nexus, if there's some connection, then a judge is going to be able to say, you are here because you were accused of driving under the influence for cannabis. I don't want you to use cannabis during the time of pretrial, mm-hmm. and I don't want you to use cannabis or then if they're convicted, after their conviction, or if somehow it ends up in front of the parole commission for that either. That would be a reason to say, no, you can't be in possession of cannabis. If there's some other crime that doesn't have anything to do really with smoking cannabis, then the judge would have to make a specific finding somehow that connected the two, and I don't think they would be able to do that. So the idea here is to basically say, you can't do that.
So this would make marijuana like in the same position as alcohol in terms of the judiciary's ability?
I mean, there's not a similar place in the law for this with alcohol, but judges already, if somebody is a DUI, they're accused of a DUI, they can be ordered not to drink. And as part of their probation, they can be ordered not to drink alcohol as well. What this is basically putting into law is, we don't want you to do this for marijuana. We want you to have basically a specific reason why this person can't smoke marijuana during the time of their pretrial and pretrial or probation.
So the judge can do it for alcohol, but not marijuana under this bill?
No, under this bill, they would still be able to do it. They would just have to make a specific finding that the defendant's use of cannabis could create a danger to themselves or others.
Okay, so it would be equivalent to alcohol then?
I believe it would be effectively equivalent to alcohol. Just to be candid, I think it is a higher requirement for this than it would be necessarily for alcohol, where the judge would have to make that specific ruling and make that specific finding that says that the defendant's use of cannabis could create a danger to the defendant or others.
Okay, thank you, Mr. Chair.
Delegate Conaway.
Thank you, Mr. Chairman. In specific, in reference to the defendant that has violated probation or parole, actually probation, I thought it was automatic that a person couldn't consume alcohol or mouthwash with alcohol in it when they're on probation. So
I think it depends on the judge. When we looked at the standard condition forms for probation, doesn't always include alcohol, or I didn't see it where it included alcohol. Usually that's a special condition.
Is that since
Under-
we changed it?
So this doesn't do anything to change what are standard conditions or what are not, but that is not one of the standard conditions that at least I recall being in the probation orders that I've seen. I've seen it as a special condition where they're not allowed to drink alcohol, but that's something that a judge would do specifically because the person had done something with alcohol.
Now, I'm aware of people, constituents, I guess you could say, that have other kind of charges and have gotten violated for having alcohol in the mouthwash.
I can't speak to that case, but I guess it would depend on what their conditions of probation were.
How do we test this or check this to find out if we're accurate before we bring this to the floor, I guess?
How do we check what to find out?
To see if, you're saying that the alcohol is kind of on the level of the cannabis, right?
What I'm saying, what the amendment would do is it would say that if a court was going to say that a person during the time that they're on pretrial or the time that they're on probation, that the court would have to say that they were making a specific finding saying that the defendant's use of cannabis could create a danger to themselves or others. They would include a condition in the pretrial release that the defendant could not use cannabis. And then if down the road that person was found to have used cannabis, they could have their pretrial or their probation violated. If that's what this amendment does.
Right.
And so what it's basically requiring is it requires judges to explicitly put on the record, I do not want you to be smoking marijuana. I'm making a specific finding that I don't want you to be smoking cannabis or ingesting cannabis during the time of your pretrial or what have you.
Okay, just so I can be clear, 'cause I'm a little slow sometimes. What we're saying is unless the judge specifically says that you cannot use cannabis while you're on probation,
Right.
it should be assumed that you can use cannabis until you're excluded from using cannabis.
That unless the judge says that you cannot use cannabis, then you would be able, that it wouldn't violate your pretrial or your probation or your parole.
Thank you, Mr. Chairman.
All right, Delegate Kaufman, then Erican, then Tomlinson.
Okay. Well, given that Delegate Ercan has questions, I guess my motion won't work, but I was going to motion to vote on the previous question.
We're going to do Delegate Erican.
It's like he read my mind. No, just kidding. I was also going to do that, but then I had a real question. So I just want to confirm, since this is prescribed medically now, how will this bill impact? So can a judge tell somebody who's medically prescribed that they can no longer take this? Because alcohol is never medically prescribed, obviously.
No, alcohol is never medically prescribed.
Hopefully not.
Again, this doesn't go to the issue with medical marijuana users. If they have they would have to, I think, they'd have a defense attorney probably.
Hopefully.
Probably somebody from the Office of the Public Defender at the minimum that would be able to make the case that they've got a medical marijuana card. And so there should not be that connection. The judge, again, would have to make a specific finding that the cannabis would create a danger to themselves and or others. If they were a medical marijuana patient, that would probably be a little harder to make that connection.
Yeah.
But that would be on a case-by-case basis.
Yeah, because I definitely have a concern about a judge overruling like a medical doctor. That makes me a little uncomfortable. So, all right, hopefully that's not going to be a problem.
Delegate Tomlinson?
There was something you had said, and then Delegate Conway had said. So, and speaking with my state's attorney's office, obviously you mentioned that with a DUI, usually alcohol is a special condition. It's not a standard condition. Usually, a special condition that's almost 99% of the time applied, that you're supposed to stay away from alcohol. And I believe Delegate Conway was kind of asking the same thing, that a lot of times people, for other folks who commit other crimes, whether it's like assault or whatnot will also be told that they have to be kept away from alcohol. But you had mentioned that you think it's going to be a higher bar, I guess, for a judge to say that you are to stay away from marijuana as compared to alcohol?
They need to, there's not an equivalent necessarily language there for alcohol. They would need to make a specific finding that the defendant's use of cannabis could create a danger to themselves or to other people. So they would need to put that on the record. Now, whether that would be something judges would do as a matter of course or not is something that we'll have to find out after the bill is passed. But I would say the clear intent of the bill is to limit this and to do it only when there's some nexus between the criminal act and the use of marijuana.
Okay.
Or cannabis. Delegate Cardin.
Mr. Chairman, just to illuminate the chair's suggestions, maybe for Delegate Conway or whomever, I have had a case where a person was on probation for for an assault in a bar where he was drinking too much, and part of the requirements for the probation was to stay away from alcohol. I've also had a client who was caught shoplifting a lot, and it was over $1,500 worth of shoplifting, and there was no requirement for alcohol because alcohol was not part of anything dealing with now, I don't know if that was a decision of the judge, but the judge did not include a prohibition on alcohol in that case. So those are some examples of how if the case involved somebody, doing something that perhaps cannabis was involved and he made a bad or she made a bad decision, and the judge believes it was partially because of the cannabis use, maybe they would make a finding at that point, a specific finding that it would do damage to them or others. So that's why I think that this language makes a lot of sense, and it clearly states the finding that the judge has to come to.
Enlightening me, and I'm fully illuminated now. Thank you.
Delegate Conway is well lit, and so now we're ready to go on with Happy Ted Lasso Day. All right, we're on the amendment to House Bill 980. All in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Anybody opposed? 1. 18 to 1, the amendment is adopted. We're on the bill as amended. There's a motion for a favorable. Is there a second? Motion and a second. Further discussion? Seeing none. The Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt? Yes. Simmons is excused. Boucher? Yes. Phillips? Yes. Tomlinson? No. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Soft yes. Valentine? No. Conway? Yes. Kaufman? Yes. Williams? 19 to 2. Okay. Now we're going to go to House Bill 800. House Bill 800 has amendments. There's a motion for the amendments. And a second. Thank you. I don't have them. Any questions about the amendments? Delegate Cardin.
The language on page 2, lines 12 through 14, and it just is duplicative language that would create confusion, and so it was requested that it be stricken.
Okay. Further questions about the amendments? There's a motion for the amendments in a second. All in favor of the amendments, raise your hands. Anybody opposed to the amendments? Tomlinson? All right, the amendments are adopted. There's a motion on the bill favorable. All right. Motion and second for a bill as a favorable. Are there further? I think maybe Delegate Tomlinson just left his hand up a little long while. That's fine. Okay. All right. Yeah, well, he actually did. It's on camera, actually. It's one of those things. Okay. But seeing no further discussion on the bill, the Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons is excused. Boucher? Yes. Phillips? Yes. Tomlinson? You sure this time? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Okay. And yes, and an add-on, Williams? Yes. Okay, it should be 21. Moving on to the first of two bills related to sexual assaults kits and clearing the backlog thereof. House Bill 759. There's a motion for a favorable and a second. Is there discussion on House Bill 759? No, says Delegate Munoz. Delegate Conaway? 89, not 58. I'm sorry, 759, not 758. We're getting to that one next, Delegate Conaway.
Okay, so there's nothing in this bill about self-administered.
No, not in this one.
Thank you very much.
All right. We'll be there in a minute. All right. Any further discussion? Seeing none. The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Excuse. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. It's a favorable. We can't do that. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. 21. 758. There's a motion for a favorable. Is there a second? And there, well, wait a minute. Sorry. Oops. Let's do the amendments first then. Let's do the motion on the amendments. There's a motion on the amendments in a second. So we're now on discussion of the amendments. Delegate Bartlett, who would like to talk about what the amendments do?
I don't mind. Okay.
Okay.
So the amendments, excuse me. Well, go ahead. Okay. Okay. So the amendments strike language in the purpose paragraph to explain that that the bill is intended to to report to the State Committee or the Sexual Assault Evidence Kit Policy and Funding Committee has to have a report by a certain date and provide recommendations. The second amendment also strikes in its entirety lines 20 through 22 and inserts within the definition qualified healthcare provider as already stated or already defined in the article. And we also mention that there are self-administered sexual assault evidence kit. Do you want me to tell you why yet, or just tell you what the amendment does first?
Do what the amendment does.
Okay.
And then we'll go into the law.
Okay, so we go into the sexual assault evidence kits and define or preclude self-administered sexual assault evidence kits from a traditional sexual assault evidence kit. We preclude the self-administered. And on page 3, we define or we include healthcare provider or hospital, and we just kind of, hold on one second, let me do it with the reprint, it'll be easier. Just one moment. Okay. Thank you for your indulgence there. Okay, so on page 3, we are eliminating healthcare provider or hospital because it shows up later. And we also change around a little bit some evidence with respect to law enforcement agency, again, because it shows, we put it in later. And then we take out all information relating to the storing and the access and tampering, and that whole section is gone. So we move all, on page 4, we move all of section 2. And then we also remove the requirements with respect to failing to store properly from the bill, because we get into the storage at another location. And we put in some uncodified language with respect to the requirements of the SAKE committee and what is to be done with respect to presenting guidelines or reviewing or making recommendations, recommendations for guidelines for the self-administered sexual assault kits. And essentially, that's everything that the amendments do.
All right, questions regarding the amendments? Delegate Conaway.
What page are we on in reference to the self-administered kits?
Sure. We start on page 2, I believe, on the self-administered sexual assault kits at line, around about line 15.
2 of 6?
No, did you see on page 2?
I'm looking at, stricken. Are you looking at 2 of 6 or?
Yes, I'm sorry, 2 of 6, yes. It's moving.
Okay, go ahead.
That was my answer.
That's your answer?
Yes.
Line 12 or line 14?
Let me look at it online, it'll be easier.
And so what's the responsibility? So is there a time limit that a person has to turn the self-administered sex kit into either the healthcare system or to law enforcement?
No, there's no time limit.
Is there a requirement that law enforcement test the kit if it's turned in?
There is a requirement for law enforcement to test the kit. I believe it's within 30 days. I'll confirm in just a second.
If a person turns in a kit in reference to what they consider to be a rape in, let's say, 4 years or 5 years, will that still be a chargeable offense?
Sure.
What's the
It depends. If the evidence leads the state's attorney to bring charges, then yes.
Can the timing of the kit being turned in extend the statute of limitations?
No.
Okay.
Right.
That would have been nice. Thank you, Mr. Chairman. Just wanted to have that on the record. Thank you.
Any further questions? On the amendment, all in favor of the amendment, please raise your hands. 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, Anybody opposed? Oh, you're a yes. Anybody opposed? Didn't see anybody opposed. All right. There's a motion for a favorable and a second. Further discussion on the amended bill? Seeing none. The Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Arakan. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams. Yes. 21. Okay. Now we're going to House Bill 440. I believe there are already amendments. There were amendments adopted by this subcommittee, and there is a proposed amendment by Delegate Arakan. Delegate Arakan, I'd like to do the amendments proposed by the subcommittee first, and then we'll go to yours. So we'll go to the subcommittee chair for a discussion on the amendments to the bill from the subcommittee.
Yes, the amendments simply outline the details of when a parent can request the court to give them an expedited hearing. And it's really whenever a parent feels that the child is going to be relocated someplace and the parent will not be able to take part in, parent time. And that is when the opportunity opens up for the parent to go to court and now ask for an expedited hearing on that particular situation of the child being relocated someplace else.
Could I have a motion on that amendment? Move that amendment in a second. Then we're now on discussion of the subcommittee's amendment. Are there questions regarding the subcommittee's amendment? All right. Then we're going to take a vote on that amendment. Then we're going to go to Delegate Arakan's amendment. All in favor of this first amendment from the subcommittee, please raise your hands. Any opposed? That amendment is adopted. All right. There's another amendment from Delegate Arakan, and I'd like, you should have all received that amendment, and I'll let her describe what the amendment does, please.
Thanks, Mr. Chair. So it's really, really simple. It just says that this is an option unless it's already been addressed in your current contract that you already have filed. So like when I had my custody agreement, we actually addressed specifically relocation in our custody agreement. So this is really just an opportunity for people to pre-discuss these things, put them into their contract, and then avoid potentially spending extra money to get taken back into court when they've already sort of worked it out in the actual contract. Because it's very expensive to go back to court. And so any way we can sort of include in the contract things or encourage people to include this kind of discussion in the contracts, I think is going to be helpful for everybody, because the more money parents spend on litigation and fighting in court, the less money they have for the children.
Arakan. But I think this bill specifically deals with emergency situations where you've got a parent that decides for whatever reason that they're going to remove the child. And obviously they've already had a custody agreement. They already know what the requirements are for visitation. But for some reason they have decided to leave the state or do something else that will conflict with that existing other parent's parenting time. So that's what this this bill is about, okay?
Yeah.
So I don't believe that your amendment is necessary because, as you mentioned, it's true. Most of the time people have already worked out their custody and their visitation time. But this, again, is for that situation that's one-off where that parent says, nope, I got to leave town, or I'm going to take the kid and do some, and go away for a while.
Right. So that would trigger the material change in circumstance clause in most people's contracts. So then they sort of already have an avenue to have that addressed.
But this is for an emergency situation. If I remove the kid 2 days from now,
okay? And I need to get to court now, that other parent, to say, suddenly my time on Thursday is gone, you know? I need to get to court on Friday to say my kid is gone, you know? That's what this is about. So goes
Yeah.
beyond what you're suggesting.
Yeah, I hear you. I think there's a lot of situations where parenting time is denied outside of the scope of just moving and relocating. So if there was a bill that allowed for that emergency thing for all the reasons that parents do deny time, then that would be a whole other sort of subject discussion. But I just feel like this could end up getting overused. So how would it work? They would come in, they would say, even though it's in my contract, this person is moving 55 miles away, and that's not in our contract. But this bill specifically puts like actual distances in it, does it not?
No, I think that was actually taken out.
Oh, good.
So that
Okay.
it's the parenting time.
Okay, that's the new amendment that you.
Correct.
Okay.
Correct. So it's
Okay.
the interference with the parenting time.
Okay, I like that better. So yeah, I thanks for making those changes. I think I'm actually going to vote for this now because I think that change is going to improve it, because I didn't want to get into a situation where I make a contract with my other partner, and then this thing directly contradicts my actual contract that we've already both consented to. So, okay, so in that case, I'll withdraw my amendment, and I think I'll probably be green on the bill. So thanks for working on it.
Thank you.
Okay. Now could I have a motion on the bill as amended? There's a motion for a favorable and a second. And now on the bill as amended, Delegate Cardin.
Madam Subcommittee Chair, was there any opposition, or did all the family law bar come together on this?
They came together on this one.
I love it. I love it. Great. Thanks.
All right. Further discussion on the bill? Seeing none. The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Add-on Taylor. Tolles add-on. Phillips add-on. Well, we haven't gotten to your vote yet. We'll be right with you. It'll be all right. Simpson. Yes. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway. And an add-on. Kaufman. Yes, and an add-on. Williams on the bill. Delegate Erica withdrew her amendment. This is on the bill without, she did not. Delegate Williams, your vote on the bill.
I'm so sorry, yes.
Okay. And an add-on.
And an add-on, yes.
Great. Delegate Pasteur is adding on. Anybody else wants to add on? Okay. Delegate Simpson. Oh, I have to correct something. I made a mistake before again, and you can add it to the list. We're coming out with a third volume. But House Bill 980 was Delegate Young's first bill, and I failed to make a big deal about that. I apologize for that, and I don't think it's his second bill. I think it's his first bill, isn't it? Oh, no, he did the first one because he said that terrible thing about City College, and then, that's right. Oh, it's his second. Oh, well, then it's not a big deal then. That's fine. Never mind. Never mind. Yeah. Oh, right, that was your first bill, right? Well, it's Delegate Young's first bill. All right. I had no comments about City College. I can't do everything. All right. So now we have Delegate Simpson's bill. There's a motion for a favorable. Is there a second? All right. Any discussion about 362? Delegate Arakan.
Thank you, Mr. Chair. So there's no amendments to this bill?
I don't believe we have received any amendments to this bill.
Okay. I think I'm just, since this is actually, not only did this happen to my congressman, but it actually happened to me. One of my first years down here where I was recorded in my office after not consenting to it. Not only was I recorded, but then it was posted online, and unfortunately they tagged the wrong person because they were really with it. So I just feel uncomfortable with minimizing the penalties on this particular crime. I think it's kind of what sets us apart and makes us a little different than other places, that people can have conversations that they feel comfortable in being honest in, because you know, we know that we can't be illegally recorded and that the penalties for that are very stiff. It's really something special, I think, and different about Maryland that allows us to have really candid conversations with each other, and I think leads to better outcomes in general, down here especially. So I'm just very uncomfortable with minimizing this to a felony. I mean, from a felony to a misdemeanor. I think it's taking our state in the wrong direction.
There are further comments on the bill. Delegate Valentine.
Thank you, Mr. Chair, and I would like to echo those same thoughts. I will also be a no on this bill, and specifically for an instance involving a domestic violence / divorce proceeding years ago that I had personal knowledge of, where a female, the wife was getting ready to leave this gentleman, unbeknownst to her back in the days when we still had home or resident phones, home phones. She unsuspectingly was located a recording device in one of her children's bedrooms that her communication had been recorded by her soon-to-be ex-husband, and literally about the only reason that he did not try to use that in a subsequent divorce proceeding was because he knew he had done it illegally. So that's one personal experience and one reason that I will be voting no for this bill.
Is there further discussion on the bill? Delegate Conaway.
Thank you, Mr. Chairman. Does the penalty stay the same if it becomes a misdemeanor? The 5 years fine, not more than $10,000?
It just goes from felony to misdemeanor. The penalty stays the same.
Thank you.
The Vice Chair.
I just want to point out that we have a number of bills. Some were requested by members of this committee requesting upgrades from misdemeanors to felonies. And the existence of those bills points out quite a number of very serious criminal offenses that some of them carry quite a large amount of time that are misdemeanors in this state. And when this law was made to make this a felony, we were talking about switchboards. So someone who was listening in was doing something actually quite deliberate and quite involved with communications infrastructure. And we are now talking about everyone carrying it around like this, and a very wildly different expectation for what's happening. I'm really sorry that what happens to some folks and what happens to the member of Congress, but charging someone with a felony is inappropriate. I could go on and on with lists of things. Carrying a illegal loaded handgun, someone doing that illegally twice, two-time offender. That's a mandatory 5 now in Maryland, and it's a misdemeanor. Carrying a handgun on school property, long gun sale for use in crime to harm someone is a misdemeanor. I'm telling you guys, this is not a good, when you stack these up, it doesn't make any sense. And I, again, put the Andy Harris situation aside, the people actually asking for this bill, other than that one kid, were the domestic violence victims. So I hope you'll keep an open mind.
Munoz, then Conaway.
Thank you, Mr. Chair. I know we voted this through committee, and I believe the floor last session. Has anything changed on this bill since last year? Or is it in the same position?
It's in the same posture.
Thank you.
Mr. Chair, if I may ask the Vice Chair a question? Sure. Mr. Vice Chair, do you think that if someone clones your phone and intercepts your communication, Do you think that should be a felony, or, I'm asking, you think that's a pretty serious offense? I mean, like, if you clone another delegate? So you think it should be a felony? Years in jail? Okay. Thank you.
Discussion on the bill. Seeing none. The Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. No. Simmons is excused, but just texted and said he'll be here on the 27th. And he's watching. Delegate Boucher. No. Phillips. Yes. Tomlinson. No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? No. Conaway? No. Kaufman? Yes. Williams? Yes. Yes. 15. Motion is adopted. We're now on 267, and I believe there are amendments, and I think Delegate Bartlett, unless you want... Okay. Normally we go to the subcommittee chair, but subcommittee chair is deferring to Delegate Bartlett on House Bill 267. So let's go ahead.
There's only 4 amendments.
Well, let's do this. Oh, talk about the amendments and we'll motion them. All right.
Okay, amendment number 1 strikes the requirement to give notice of intent to travel and adds language to establish the requirements for a petition under the bill and provides the court with risk factors, requirements for a prevention order, and authorizes the court to issue a warrant for physical custody of a child. The other changes are technical, and we are removing section 9-106 and 9.7-108 from the bill as they weren't needed and they weren't necessary, and we added section 9.7-111. Amendment number 2 strikes section 9-106, as I just mentioned, because it's already in Maryland law, and the bill does not affect that section. Leaving it in was confusing. We also have a technical amendment to fix the definitions of abduction and wrongful taking and wrongful keeping. Amendment number 3 is a technical amendment to add definitions and distinctions as to what is not included in the definition, and authorizes the prosecutor or public authority, namely the Attorney General, to seek a warrant for physical custody or other prevention measures, and fixes the numbering. That's all. Okay, so amendment number 4, last amendment, deletes the words UCCJEA because we don't need them to identify that part of the code. This is the part that we had already adopted, and we have it enumerated differently. So it's more straightforward to just refer to our section of existing law. We strike the language that was included inadvertently regarding customs and borders that just wasn't supposed to be there. This way, it's more accurate, it's more straightforward to simply say the petition shall specify the risk factors and reference back to where they are in the bill. We also strike that portion of the bill regarding mediated custody settlements, divorced parents, parents with foreign citizenship, employer's name, financial, etc. These are things nobody liked, and we replaced it with vetted Uniform Child Abduction Prevention Act risk factors according to the Uniform Law Commission that has been vetted. Those are the amendments.
Take a motion on the amendments. Motion and seconded. We will now go to discussion on the amendments, and Delegate Erican. If other people want to be recognized, just do what you got to do. Delegate Erican.
Thank you, Mr. Chair. Okay, so I'm just looking through all these changes. This is like quite the dense piece of work, so good on you for working this hard on this. So I just want to understand practically what could happen. So what would be the triggering thing that would allow somebody to then, is it this, I guess this is a new pathway to get into the court. So what triggers someone to be eligible to use this?
Well, there could be two triggers. One, an individual could file a petition because they know the risk factors and perhaps they want to bring to the court's attention one of the risk factors. Or the court on its own can review the risk factors and say this individual is someone who could who could abscond with the child.
On its own, like in a custody hearing, like it's a separate thing, or how would they be alerted to that? If
Well,
it's on
yeah,
their
it would
own?
probably be a custody situation, or the court could be, the court could be there in a custody matter or some other matter in which, in family law.
Okay. All right. And then I see on page 7, if you're in the packet, it's 12, like in the amendment packet, it's page 12. It's sort of going through this list of things. I think it's an or. So the person is eligible if the respondent has previously abducted the child, has threatened to abduct, has recently been engaged in a list of the following activities, including abandoned employment, selling a primary residence, terminating a lease, closing, bank accounts, financial things, applying for a passport or obtaining travel documents for the child, or seeking to obtain the child's birth certificate or school or medical records. So, like if I went to get a passport for one of my kids, that could trigger it so my partner could then take me to court over it?
No, not necessarily. So we define travel document and we exclude passport as a travel document. Travel document is actually going to get your plane tickets or your itinerary.
Oh, it's on.
Yeah.
Do I have a wrong amendment then?
No, you got the right amendment.
'Cause it says passport right here.
Right. So here we go.
Okay.
Go over to page 8 in the amendment packet.
Okay. 8 in the amendment packet.
Yeah.
Okay.
So it's at section J1.
Okay.
Where we say travel document means a record relating to a travel itinerary, including a travel ticket or pass or reservation for transportation or accommodations. Travel document does not include a passport or visa. Okay? So now when we go back to 12 with that definition.
Of travel document.
Yep. So that definition is on page 8. And then we go back to 12 where you were.
Yeah, 3V.
Yep.
A3V.
Right. So applying for that passport or visa.
Yeah.
Or obtaining travel documents for the respondent. So you're applying for it. That's what they're talking about. They're not saying so it's just that you're applying for. All of these things kind of are triggers.
Right, but they're
right?
all
So
ors.
it wouldn't be the one thing. It wouldn't be the one time you go and you try to get a passport for your child. That wouldn't be the trigger. The trigger would be these types of activities that you are falling into, so that perhaps the more risk factors, the more one is inclined, the court could infer that the person is inclined to abduct with the child. But applying for the passport alone is not a sufficient indicator or grounds.
Is there a metric, though? Because the way I'm reading it just says or after each thing. So there's no and like I don't see is there a metric somewhere in here where the judge should say, like, if it's over this many things, then, the person's a risk? Because I'm a little worried that it definitely says passports. Is applying
right. Well,
for passports.
you still would have a burden of proof. So you could walk in. Sure, you could do that now. You could walk into court and you can say, my husband applied for a passport for my child. You're not going to be there very long. So that's the same way that this would apply. You can walk. You're going to go in, but you're going to go in with as much evidence as you could possibly bring. So you would bring the tickets. You would bring applying for the passport. You would bring a stack so that you could prove your case. But simply coming in to saying that, my husband applied for a passport for my child, that in itself would not be enough. No, there's no matrix, but there is the the burden of proof that you would have anyway.
Yeah,
In going
okay.
to court.
So, I mean, I remember when, I think this was Delegate Cardin's bill many
Yes.
years back. Okay, I remember the testimony, it was really disturbing, and I definitely felt like there was something that could be done. My concern, as with a lot of bills, is the potential to have a narcissistic abuser weaponize the court system against the victim. And so I shy away from bills that feel like someone could use any opportunity to drag the victim back into court to renegotiate a contract where there's really no material change in circumstance happening.
Right.
So as many avenues as we give some of these abusers, they will take them and they will drag these families over and over into court. So requesting medical records, school records, these kind of things, changing their address. Someone smart who knows how to victimize people could use these things to really bludgeon somebody and really make them afraid to do really anything. So
Yeah.
that's a little bit, it's such a long bill,
Yeah.
and there's just so much in here. And that passport thing is probably one of many things that stood out to me. So I'm a little uncomfortable with it just because of that.
Yeah, and I can understand that because any one of these factors alone could, be a little scary. Terminating a lease, that could be a little scary. But you wouldn't go in there alone with terminating a lease. Like I said, you could go in there, and there are many people in family law, which is why I don't practice in family law anymore,
Right.
that go in with the smallest
Yeah.
little thing,
Yeah.
and they do it, and it becomes like a way of life. And I get that. But we also have the courts. We have the courts who will review the evidence and will be able to look at it and say, wait a minute, this is a nothing burger, and you're out of here. Or they may look at it and say, wait a minute, you quit your job, you terminated your lease, you've been accused of domestic violence before, blah, blah, blah. You would look at the factors as a guide to determine, to reach that determination.
Yeah, I think I'm glad that you guys are trying to touch on this issue because it does scare the crap out of me. It's really scary to think someone could just leave the country with your kid. But I just don't know if I'm comfortable with all of this language in here. So I may be a red on it just because I fear for the woman who's financially at a disadvantage than her partner, and he's already been using the courts to drag her in repeatedly. This is potentially just another avenue for him to say, well, Judge, she requested the medical records, and she got their passports in the last month, and here she is again. She has no money and can't keep fighting like this. It makes women give up, frankly. So I'm probably going to be red on this one.
Okay. Delegate Simpson, and then Cardin. Are you okay? Delegate Simpson and Conaway.
I know we made a lot of changes to this, and my understanding was then it was based on that you found other states, and that's why we made a lot of these changes, that this is tried and true.
Right.
Yeah.
That's exactly what it is. I think there are about 18 states that have adopted this language, and that's part of, Judiciary did weigh in on this. That was a question that was asked in subcommittee, and someone asked, well, would Judiciary like this better than what was originally presented? And I was looking at Judiciary's testimony, and it's so interesting because they actually said it was the drafting issue that they had with it prior. And they laid out a couple of things that I was almost surprised I didn't see and I'm not speaking for Judiciary, but they wanted something clearer. They wanted something, clearer, and something like this. It is tried and true. It is uniform language. It has been vetted in other states, and so that's why we came up with this. That's why we came up with it.
Turn me to a green.
Delegate Conaway.
Chairman, I was wondering, is there a receipt that's required if a person gives a written notice? Do you know?
I'm sorry. You mean for service?
Yes.
Okay. For service, I think personal service would probably be required, but I'm not sure.
The reason why I'm asking is because when I was 16, I went to Acapulco, and I could go in by myself, but someone was younger than me, and they had to have permission, and they had to have written permission, so we had to get permission flown down from the House of Delegates. So.
Oh, well.
It's my sister.
Okay.
Are there any more questions or uncomfortable statements that anybody else would like to make? Seeing none on the amendment. All in favor of the amendment, please raise your hands. Anyone opposed to the amendment? All right, on the bill as amended, there's a motion for a favorable and a second. Any further discussion on the bill as amended? Seeing none. The Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes, We're really calling it that for this bill? All right. For Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Boucher. Yes. Phillips. Yes. And an add-on for Phillips. Tomlinson. Yes. Erican. No. Taylor. Yes, and an add-on. Simpson. Yes, and an add-on. Grammer. Yes. Young. Yes. Valentine. Yes. Conaway. Yes, and add. Kaufman. Yes, and add. Williams. Yes, and add. 20. All right, now House Bill 223, the Vice Chair's bill on facial recognition technology that made it out of the criminal law subcommittee, and with that, there are amendments. Oh, are there amendments? So let's let the Vice Chair tell us what the amendments do.
Okay, well, let me move the amendments.
Well, do you want to tell us what the amendments do, then we'll move the amendments.
Why don't we, why we gotta do it in that order? Yeah, okay. Okay, so this bill originally came in a few years ago with Senator Sidnor, and it is attempting to rein in and create ground rules for the use of law enforcement facial recognition technology, the type that has become famous after the January 6th investigations, whereby you have sophisticated software and algorithms that are running through people's social media databases and things of that nature to try and identify suspects. So other states have put moratoriums on this and have banned the practice. But what we have attempted to do should follow in the footsteps of what we did with forensic genealogy, which is to create a very limited set of crimes for which this technology may be used, and to start to put in other ground rules on evidence admissibility and things of that nature. So let me first start with the crimes, and I have handouts for everyone, so I'll just take them and spread them in either. Actually, let me keep one for myself. And I'll go ahead and read this for the public since you don't have the handout. But the amendments, and the amendments were unanimous in subcommittee, just to be clear. So this was a bipartisan consensus product that we have here. So these are the proposed list of crimes for which you could use facial recognition technology. Crime of violence is defined in 14-101. Human trafficking under Title 3, Subtitle 11. First or second degree child abuse. Child pornography under 11-207. All hate crimes under 10-304. There's a series of weapons offenses spread out in both the criminal law and public safety articles. I'll just quickly rattle through them. Firearm at school, disarming officer, firearm use in crime, wear carry at public school, wear carry to injure or kill, sale or transfer of an assault weapon, sale or transfer of a stolen gun, trafficking guns into the state, knowing participant in a straw purchase, sale or transfer of a long gun for a crime, sale or transfer of a firearm with a deleted serial number, sale or transfer of a ghost gun. 2 aggravated animal cruelty. This is, the one has the mutilation and bestiality, and the other is about dog fights. Fentanyl importation, and then catch-all that is crimes involving ongoing threats to public safety and national security, and then fugitive warrants from other states. This set of crimes was also mostly worked out with the state attorneys, the public defenders, and the like. So I'll pause there. Are there any, I guess, questions about this list of crimes?
Questions for the vice chair at this point?
Okay.
Keep on going.
All right, so that's the list of crimes. Then when you go to the bill itself, I'm sorry, let me get it in front of me. There were a number of policy questions we worked through, but basically what we did was the bill as amended makes the Police Standards and Training Commission come up with a statewide training regimen for facial recognition technology by 2025. Maryland State Police would put together statewide rules for departments using this program. And there are a number of ground rules too. This can only be used to generate leads for suspects. It can't be the sole thing used to bring a suspect in on a crime. There's some discovery items. It's a limited set, and we had some debate about this, but the people who are the subjects of these searches would be notified of that, as well as what software was being used, what databases were searched, and what relevant results were returned from the search. There was one, I just want to be candid about where some of the flashpoints were in the discussion. There was some discussion about whether this should be allowed for juvenile suspects, and we left that in the bill. I know OPD and some others wanted it out. And so I just want to explain to folks the overall context for why this bill is in this posture. So again, we're on year 3 now of these discussions. Law enforcement in the state is currently using this technology for whatever they want with no restrictions, including in my county. And so they've come forward to the table agreeing to voluntarily cap their activities on this. And this is what the process of working with this bill has been, trying to get to a common sense set of ground rules we can all live with the understanding that if we pass no bill, they'll be able to do whatever they want. So that's the bill. Yeah, are there any questions?
Questions for the vice chair? Delegate Conway.
Yes, thank you, Mr. Chairman, Vice Chairman. Yeah. Page 3, number 9, you said that the juvenile part is still in, but what the copy I have is stricken?
That was banning its use for juveniles, so we deleted the language that was banning the use. And again, just to elaborate on that, not everything's going to get solved either on the House side, but again, this has been a 3-year negotiation on this, and we're running out of time. We got to get a bill over the line. So any remaining debates people want to have
Right,
can
so
happen
the question
across the
is,
street.
so
Yep.
you put the
Yeah,
juvenile,
there was a ban on the use of this
I
for
understand.
juveniles, and we took that language out.
so now the juveniles can be included in the facial recognition, is that correct?
Correct.
Okay, thank you very much.
Yeah, and again, just to clarify that, if we don't know, that if we're looking for a crime suspect, it was unclear how you would know that it was a juvenile you were looking for unless there were very specific facts indicating that.
Delegate Erican.
Yeah, that's what I was going to say. That this is still, again, juveniles only for these prescribed things, and the reason was because we wouldn't be able to tell in advance if the person we were looking for was a juvenile or not. It would be impossible to know in advance. So.
And they still wouldn't be subject to, unless they could be subjected to criminal prosecution. So this wouldn't change that.
We got to do the amendment, so now motion on the amendment. Move the amendment. Second, okay. On the amendment. Any further discussion on the amendments? Seeing none, all in favor of the amendments, raise your hands. Anybody opposed? Amendments are adopted. We're on the bill as amended. Is there a motion on the bill as amended? A motion for a favorable and a second. All right. Any further discussion on the bill as amended? Seeing none, the Vice Chair. Yes. Yes, Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. Yes. Taylor. Yes. Simpson. Yes. Grammer. Yes. Me too is possible. Yes. Young. Yes. Valentine. Yes. Conaway. And an add-on. Yes. Kaufman. Yes, an add. Williams. Yes, an add. Does anybody else want to add? Phillips. Cardin wants to add on, despite Tolles, Cardin, Tolles, Phillips, Pasteur. Anyone else? All right, over Delegate Conway's strong objection. We will let them add on, yes. And two more Me Too's with Taylor and Simpson. Okay, let's do this. We're going to go to 612. We're going to go to 612. Delegate Watson, and I know we've got 135. 612, the Licensed Tree Experts Bill. It's the trees. And we are secondary to the Environment and Transportation Committee. Apparently why Jeremy's here. Okay. We've had discussion on the Licensed Tree Experts Bill. Were there amendments? Did we adopt the amendments? We did not yet. The amendments, according to Delegate Munoz, are great. Could I have a motion on the amendments, please? Motion for favorable, or on the amendments, is there a second? A second. Apparently doesn't matter that Jeremy, okay. Sure. So we have a motion and a second on the amendments. Delegate Munoz, do you want to explain the amendments on the bill?
Thank you, Mr. Chair. Delegate Cardin, the amendment changes the requirement for all tree experts to be licensed. Only those working above 200 feet or higher, which is an incredibly dangerous level, are going to be required to have their own individual license under this amendment. You're very welcome.
Claire has some clarifications. Claire, go ahead and give us your clarifications.
Well, the requirement to be a licensed tree expert only applies with regard to trees that are over 20 feet tall, and that's current law. The bill's not changing that.
So what are the amendments?
So would you discussed the bill with the Environment and Transportation Committee. Could you give us a sense of what the bill would do with the amendment, please, Claire? Would you do that?
So the bill is It's a consumer protection type bill, which is trying to make the tree care and tree trimming industry safer for the public, people who hire people to take care of their trees, also the workers, because it's a very, very dangerous field to work in, and also trees themselves. And currently there's a problem where people, you have to be licensed to become a tree expert, and that means you have to go through certain training and have a certain background. But some companies that want to do tree work, they're not licensed tree experts, but they're able to pay somebody who is a licensed tree expert to just work under their license, but they're not actually being supervised in any way by the licensed experts. So there are some people out there who are doing tree work who really don't have the proper training and background, and that can be dangerous, and they can do harmful things to trees, causing trees to get diseased and die. And it can, the people who work in the field can get hurt, and the public can also get damaged. So the bill is trying to clear that problem up, and the committee, there was somebody who opposed the bill, somebody in the industry who thought that the language of the bill would prevent these large tree companies from coming into the state and doing work. And so the committee thought that guy did have valid concerns, and so they crafted the amendments to address his concerns, and they think that it does address the concerns, and that the bill should stop the practice of people who aren't qualified doing this tree work. But it does allow, anytime there's some kind of qualified supervision involved, the bill would allow that.
Questions for Claire at all? So the amendment, what does the amendment do to
The amendment addresses the opposition. So as the bill is introduced, said a person may not engage in the work of the treatment, care, or removal of trees for compensation under a tree expert's license unless the person is employed by the licensed tree expert. And that was deemed to be too restrictive. And so the amendment expands that to just say, or if you employ a licensed tree expert who can provide oversight, or you're employed by a company that employs a licensed tree expert who can provide oversight, or if you yourself are a licensed tree expert. So, either if you are an expert or you're being supervised or overseen by somebody who is a licensed tree expert, you can engage in this work. But not if you're just paying somebody else to use their license and they have no supervision or oversight over you. And that is the main thing that the amendments do. I also insert the word physically in there. And yeah, that's the main thing that the amendments do.
Move the amendment, Mr. Chair.
motion for the amendment and a second? Further discussion on the amendments? All in favor of the amendments, raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. Anybody opposed? The amendment's adopted. We're on the bill as amended, again, secondary to the Environment and Transportation Committee. There's a motion for a favorable and a second. Any further discussion? Seeing none. Delegate Munoz.
Yes.
Delegate Crutchfield.
Yes.
Delegate Cardin.
Yes, because I'm a tree lover.
That's nice. Delegate Bartlett. The first three votes were yes. Delegate Bartlett. Delegate Embry. Delegate Pester. Delegate Tolles. Delegate Schmidt. Delegate Boucher. Delegate Phillips, Delegate Tomlinson. Yes. No, we're not. It's E&T. I can't do that. No, because they already voted for it. Erican. Taylor. Yes. Simpson. Yes. Grammer. No. Young. Yes. Valentine. Yes. Conaway. Yes. Kaufman. Yes. Williams.
No, I cannot explain my vote.
Yes.
So I love the trees. I hope the trees love me back. I have no problem with the fines in the bill, but I do have a problem with the 1-year imprisonment in the bill for not getting a license.
The Vice Chair. 17-4, the motion is adopted. With favorable with amendments. Now, we are on House Bill 135. There are amendments, and the Vice Chair is going to explain the amendments.
Okay. There are amendments to this bill. They are pretty substantial. So the bill came in with an effort to delete 2 mandatory minimums in the law regarding cannabis, volume dealers, and kingpins. And I think it proposed a change from a mandatory 5 and a mandatory 20, both felonies, to a misdemeanor 5, felony 20 max on both. And so the amendments would change volume dealer of cannabis, 50 pounds, to a 10-year, from a 5-year mandatory minimum felony to a max 10 misdemeanor. It would take the cannabis kingpin mandatory minimum, currently a 20-year felony, and make that a max 20 felony. So we'd remove both of these mandatory minimums and replace them with maximum sentences, and it would change one of them, the lower one, from a felony to a misdemeanor. Now, the bill is introduced to not include a provision allowing people who are currently trapped in these mandatories to have resentencing. So the amendment would propose that you can apply for a hearing for resentencing within 3 years, and if you're denied, again, in 3 years. There's a second volume dealer and drug kingpin section of law that is going to be brought into the bill by amendment. And this relates to crack cocaine. And the reason for it is this. In 2016, when we passed the Justice Reinvestment Act, one of the things we did was we changed what amount of crack gets you this 5 or 20 mandatory minimum, because it was 50 grams for crack and 448 for cocaine. So in 2016, we decided to make them the same at 448 to solve the crack cocaine disparity you may have heard about. Once we changed that, it was no longer a mandatory 5 or 20 to have, say, something less than 448 grams of crack. But we didn't do anything for people who are left in prison under the previous sentence. In 2019, the House passed a bill to give those folks a hearing for resentencing, and the Senate didn't move it. So we are including that here on this bill, and we are bringing in people who were sentenced to a mandatory minimum for crack as a volume dealer or kingpin, who are currently incarcerated under a mandatory offense, and for whom that amount is no longer a mandatory minimum. Those folks can apply one time for a resentencing, as was contemplated in the bill we passed a few years ago. So that's now in this bill. The third justice reform that's in this bill, we call it the Grammar Brownie Batter Butter Bill, relates to clarifying that the criminal prohibition on manufacturing or producing, being a cannabis product producer, does not apply to ordinary things like baking brownies out of, for personal use or sharing. So for non-commercial purposes, that would be clarified in the bill. The bill now also brings in 3 firearms offenses for penalty reclassifications. They are sale of a stolen firearm, sale of a firearm where the serial number has been obliterated or removed, and the sale or transfer of a ghost gun. 2 of the 3 are currently 5-year misdemeanor offenses and would move to 5-year felony offenses. That's the ghost guns and the stolen guns. The obliterated serial number offense is currently a fine-only offense, and it would become the same as the ghost guns and the sale of ghost guns and the sale of stolen guns and the sale of guns where you've deleted the serial number would all have the same 5-year felony on it. There's no penalty. There's no increase in the number of years. It's a change from misdemeanor to felony status. They would all be made the same. And those 3 I call it sale of sketchy firearms. The sale of sketchy firearms offenses are on the same amendment with the resentencing of the mandatory minimum crack and cannabis volume dealer and drug kingpins. Okay. Are there any questions?
Delegate Conaway first. I see many.
Thank you, Mr. Chairman. Thank you, Vice Chair. So when you say you can share this cannabis, can you share it for money?
No.
Okay. And can people pitch in and buy a bale of it together? Yes, a bale. This thing is talking about 50 pounds or more of cannabis. The reason why I use the term bale is because a 2-string square bale of hay will generally weigh between 40 to 75 pounds. So if you go to one of the farms, you say, can I get a bale of hay?
I assume there could be co-conspirators in a 50-pound operation. Yes.
And then why are we mixing this in with the other things that all amounts of the other substances are illegal, but the amount of this cannabis is going to be legal? So why are we mixing the 2 together?
Well, we're not. The goal is to separate them and to try and start making a distinction now that the cannabis is the legal one, that the mandatory becomes inappropriate. But once we embarked on the task of deciding to allow resentencing for people who are trapped under the previous sentence, we started looking at whether we should take a more broad look at how we deal with the sale of illegal drugs and guns overall and do a little bit more of a comprehensive rearranging.
I was on the cannabis because I didn't get to ask you, and I didn't get a chance to look it up because you were explaining the bill very thoroughly. How much cannabis do you need to make a batch of brownies? I don't know.
I think it depends how many brownies you want.
Okay, thank you very much.
Delegate Arakan.
So this has kind of turned into like the omnibus bill that you've always dreamed of. I'm just wondering why you did not include the attempted murder going from 30 to 40 years, since it's covering almost every other possible subject area ever.
It's not. It's really just limited to sales of contraband.
Not the guns.
Yeah, these are sales of illegal guns and sales of illegal drugs.
Oh, sales of guns.
Yeah, it's only gun sales.
I thought it was theft. It's theft of guns.
No, it's sale of a stolen gun.
Sale of a stolen gun.
It's sale and it's possession of a stolen gun too.
That is true.
So that it's sale and possession. In order to steal a gun, you have to possess it.
Oh, so it, yeah, so it includes
But it might
other
not be
things.
the theft of it. I could have handed
But
it off to
it's,
someone.
but it's still included, so it's not just drugs. It's in general, like, it's a cleanup bill, essentially. It's omnibus cleanup bill, that's what you're doing. Yeah.
Yeah, but on sales, again, it's mostly sales of contraband, like, it's sale, possession, transfer of a stolen firearm, and on the obliterated serial number, it's manufacture, sale, transfer. So it's not exactly a sale.
It's in the criminal law article, though.
Yes.
So we could easily include changing the 30 to 40 years, since that's another issue that was an oversight, couldn't we?
One could try to omnibus lots of things onto a bill like this. I think it's
feels like
appropriately
it's-
balanced at the moment.
It feels like it's already quite stuffed, but there might be room for this one extra piece.
Delegate Boucher, then Tolles, then Simpson.
Thank you, Chairman. Vice Chairman, I thought the handgun roster was obsolete. That still exists?
That's the existing part of the law, yeah. We did not change that. So we didn't tamper with the existing part of the law, but we glommed on to, there's a subsection in that section of code that's about sale or manufacture of the obliterated serial number. So the handgun roster is just another subsection of that criminal law. Separate offense, yep.
Delegate Tolles and Simpson.
Thank you, Mr. Chair. Mr. Vice Chair, I was just curious, are these amendments different or similar, or it doesn't matter in terms of what the federal standards are? I know there's been changes federally, but I'm not sure how that, if it's similar to what is being done here, more specifically as it relates to the ghost gun portion and the grams.
I have no idea what you mean, whether there's a federal crime on ghost guns that is not a felony?
No, I'm just saying if this is in line with federal, or we doing something different or similar.
I'm sorry.
Are we being more loosey-goosey, I guess is what I'm asking.
You're comparing what our law is to federal law in these specific
In
areas?
terms of I may have to go back to the Justice. I wasn't here during the Justice Act or whatever, but I'm trying to figure out, based off some of the, conversations around, cannabis and reducing, sentences for that. Is it, I guess, similar to what's being done federally, or?
It's similar to, so you're talking about most recently the changes
Yes.
that they made in making crack cocaine similar to powdered cocaine. And that is what Justice Reinvestment did back in, it was 2016? 2016 is they sought to do that. What the Vice Chair's amendment, as I understand it, would do, would remedy an issue where people were convicted of volume dealer, or of kingpin effectively, during that time for an amount that was less than what the limit is right now. So it's actually seeking to give those people the opportunity for a modification, a one-time modification of their sentence.
Sort of what the Clinton era did, making those changes.
Seeking to fix that part of what the Clinton era did, yes.
Okay, thank you.
Delegate Simpson.
Why the increase in the sentencing?
Increase in
Why are
which
you going
sentencing?
from 10
I don't
to
think there's
20
I see. It was a mandatory 5 on volume dealer or felony, and it's going to misdemeanor 10, up to.
And one of them's 20. It just seems like
Mandatory
we're
20.
increasing. We couldn't make it a misdemeanor and leave it at the 10 or leave it at the lower. We had to go higher.
I mean, I'll take a swing at it.
Go ahead.
So it changes a mandatory 5 and turns it into a maximum sentence of 10 So people wouldn't be getting the mandatory 5 for volume dealer.
Okay, okay.
On the other one, it takes the mandatory 20, they would have to get a minimum of 20 years, and eliminates the mandatory of 20 and says you can get up to 20 years for being in possession and being a kingpin of more than 50 pounds of only cannabis, of cannabis. Doesn't apply to anything else. It only applies to cannabis.
And let me also try and, we had a long conversation about how to adjust over weeks, how to align these penalties. And believe me, I would have done a lot more damage to the code than what you're seeing here. But I think part of the thought, yes, constructive damage. I think part of the thought is we are very likely going to be having to revisit these cannabis thresholds, the thresholds and the penalties over the course of time. Because one of the arguments I made for getting rid of the mandatories in the first place is that we're going to suddenly start seeing a bunch of people, because it's not just 50 pounds, it's 50 pounds in 3 months. You're going to see people buying marijuana legally and selling it in Maryland, legally purchased marijuana. You know, they're going to be doing it. It's just happened in every state where this is going on. And so, you know, the opening salvo is to take the mandatories off, leave some flexibility if there's a more egregious case. We keep hearing about these cases where we're still in this gray area where cannabis is turning up with firearms. Again, we think once we get more legal businesses operating that hopefully that will start to change, but this is what folks are comfortable with at the moment.
I do agree, we're probably going to have to look at those amounts, especially since people buy it, and then if they don't use it, they could end up and have multiple people in their homes. Yeah, it could be. But thank you.
Volume is 50 pounds. 50 pounds? Delegate Taylor, then Delegate Phillips.
Yeah, whatever's in your hand. If I've already satisfied, under this new law, if I've already done the time that now this new law says, you know, hey, you know, you had a max 20, and I've done 22 or whatever it is, am I automatically expunged, or did I hear you say that you had to apply and you only get one chance at it?
On crack,
That's just for crack.
that's what was, because look,
Okay.
so on crack, the mandatory minimum is still going to stay in the law. It's just not at 50 grams anymore. It's at 440 whatever. So there's still a mandatory that's going to exist in perpetuity on that issue. That's not something we are addressing here. The JRA bill that passed in 2016, and when we tried to fix this in 2019, it contemplated a one-time resentencing ask. And we didn't put that on the cannabis because cannabis will be legal going forward. So as I note, we anticipate there's going to be further conversations about whether we need to further adjust those penalties. It's something. These folks are currently stuck there.
Yeah.
Delegate Phillips.
So, Vice Chair Moon, I want to make sure I'm clear. A person who was charged as a kingpin and their only infraction was selling weed would be eligible then for this treatment.
Oh, I don't know it's their only infraction.
But I'm saying, if they had other infractions, then they still have to deal with everything else that they were charged with.
If they were charged with if they were convicted.
If they were convicted with other crimes.
Of kingpin, and it was kingpin fentanyl, kingpin heroin, kingpin something else, then that would be, that's not covered by this. It's only if they would be able to ask for a modification if it were a kingpin related to cannabis.
Yep. And the reason I ask that question, because sometimes we lose sight of who this will apply to and how many people it will apply to. Do we have any perspective? Because I'm actually thinking it may not apply, because unfortunately, most people who were charged with this kingpin statute were charged with other things as well, and they're probably, unfortunately, going to still be caught up.
They will stay in for what they're sentenced to for the balance of the other crimes, but they could modify this part out, or down, I should say, not out, down. They're still going to be doing time if they were a crack or a cannabis kingpin, just not the mandatory. I just want to remind you, we had someone in here at the bill hearing on that. Actually, the reason this even came up, they flagged that we didn't talk about the mandatories when we did this was someone whose son was caught, I think, a few years ago, and is in for a 20-year mandatory. So there are people.
But, Delegate Munoz.
Thank you, Mr. Chair. Just by way of explaining my vote, I really appreciate the increase in the penalties for the illegal gun crimes. But doing the math, I found that in the U.S. there were 98,268 people that died from preventable drug overdoses due to these specific drugs. And there were only 48,830 people who died from firearm deaths. So due to that reason, I'm going to have to be a no on this particular vote.
Delegate Munoz, would you yield to a question?
Yes.
How many of those people died from an overdose on marijuana?
So this only takes out suicide, homicide, and undetermined intents.
Okay.
And that's the best numbers I could get. But if you have any better ones, that would probably make me feel better.
I guess the sense that I have is that
Do people overdose on marijuana?
I think would have to be an awful lot of marijuana. I don't believe that people overdose on marijuana in the same way that they overdose on heroin and fentanyl. And so we did not include anything else in this other than those people who were convicted in the past. First, the main part of the bill, we didn't include the drop in penalties to anybody who wasn't involved with the illegal sale of kingpin sale of marijuana. We just kept it to that, not anybody else. So that's, I guess, my point.
So this bill's only kingpins dealing with marijuana?
It does that, but it also addresses an issue left over from the JRA that says for the people who were caught in effectively a window between 40 grams and 446 grams, where the sentence was equalized between crack cocaine and powdered cocaine, that they would be able to get the benefit of the bargain in between the 40 and the 446. Am I right in saying that? 50, I'm sorry, 50 and 446. So it does impact those people who were convicted and in fact in the bill, who were convicted of kingpin or volume dealer before 2017, at the time that the JRA happened. So it does not address people who have been now charged under the current rules that has equalized those two. It's only reflective of people who may still be incarcerated, who got a mandatory minimum on that, and they had an amount that was somewhere in between the 50 grams and 445 grams of crack.
And so the 445, is that below the
That's the
kingpin
volume
level?
dealer, yes.
Now it is.
Now.
Because you're changing what a
Because in
kingpin
2016, we changed it.
Changed it several years ago.
Okay, thank you.
Delegate Schmidt.
I think I wanted to kind of follow up on your question. I think it was brought up in testimony, and I can't remember what bill it was, but the fentanyl seems to be the leading cause. So you brought up about marijuana, and I think they had mentioned about fentanyl showing up in marijuana recently, and I don't know, I don't have the source to cite, but I think it goes to what Delegate Munoz was saying about the drug overdoses. Fentanyl still seems to be the leading cause. So, for what it's worth. Isn't that so?
That's fine. So that would not be at all addressed. Fentanyl would not be touched by this at all. Okay, on the amendment, all in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19. Anybody opposed to the amendment? 20, yeah. Anybody opposed to the amendment? 1. The amendment is adopted. We're on the bill as amended. Is there a motion? There's a motion for a favorable on the bill as amended in the second. Is there further discussion on the bill as amended? Seeing none. The Vice Chair? Yes. Munoz? No. No. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Boucher? No. Phillips? Yes. Tomlinson? No. Erican? I'm sorry, no, correct? No, okay. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. Motion is adopted for favorable. The last bill we have is 1071. Delegate Schmidt, you asked for more time to convey more information from people that you had heard from on the bill. We're in the discussion on the bill. There's been a motion and a second. Do you have anything further you'd like to say on the bill, Delegate Schmidt? So,
Do I have an opportunity for an amendment?
at this point, we're on discussion on the bill. So we've gone past, we've adopted the amendments. We're on the bill. We're on the bill as amended. While you're thinking, Delegate Tomlinson.
So we cannot do an amendment. Since it was held an hour ago, I did submit one over to the amendments office.
Okay. What's the amendment? We've already done the amendments to the bill. We're on the bill, and we're discussing the bill as amended. So if you want to have further discussion, that's fine, but we're going to go from here to a vote. So if you have something you'd like to say about the bill, that's fine.
Who wants to offer an amendment?
Okay. So what I brought up during the hearing, and some other people had brought up as well, what was not so much the issue with, I know the primary focus on the bill is pulling people over on the sole, with the sole reason that they smelled cannabis and searching a car. That's not what exactly I'm focused on here. What I'm focused on is a problem that really already exists, and I think is just going to probably get worse once recreational cannabis is legalized this summer. And I'll just give 2 examples. I mean, I take the train, the metro, from Owings Mills all the way down to the city for work. Some days there'll be somebody on the train, not openly smoking marijuana, but clearly they just had smoked somewhere, and they'll come, and the entire train car will just absolutely reek of marijuana. I mean, my head almost hurts by the time I get off the train. And then I'm thinking of the boardwalk in Ocean City. Sometimes you'll be walking there, there's tons of families, and there'll just be entire sections of the boardwalk that just absolutely reek of marijuana. And these problems already exist, and I fear that this is only going to get worse once the recreational marijuana is legalized. So what I was trying to come up with, and what I wanted to propose, and what I submitted over to the amendment office, was something I thought that could maybe fix what I was concerned with. Obviously, there's already public intoxication laws normally applying to alcohol, and I wanted to possibly make an amendment to also apply these same civil offenses that are in the bill now. The civil offense punishments that are in the law now, or in the bill now, and apply them also to public cannabis intoxication, but only when it's breaching the peace or causing a disturbance or harm to another person, basically affecting somebody else's quality of life. So that's what I wanted to do, what I wanted to change to the bill, but I don't know if I can do an amendment at this point.
We'll go to Delegate Schmidt, then Delegate Young.
Yeah, I just want to piggyback on that. I mean, the question is, do we have similar language for alcohol, odor or site, open container? I mean, is that able to search a vehicle for the sole purpose?
If they were driving while under the influence of alcohol, what's in Section B of the substantive part of the bill outside of the fees, what's in Section B reflects where they can search inside the car related to driving while under the influence of alcohol. So they can, if they pull over the person based on driving under the influence, they probably see red bloodshot eyes. They could perhaps at that point smell the odor of alcohol. So they will have seen bad driving, so they see more than just than smelling the odor. They then conduct field sobriety tests. They determine that the person has been driving under the influence. Based on the field sobriety, they get probable cause that they were driving under the influence, and then they can search the car for evidence of the driving while impaired by alcohol.
And we still don't have a measure of the THC level when we're doing those field sobriety for.
There is not a test that measures THC levels. There's a that measures present THC levels as opposed to THC that may have been in the system from some time in the past.
So really hinders what law enforcement can really do. And that's why I'm asking for a hold on this, so we can.
Law enforcement, again, they would be able to search the cabin of the vehicle similar to the way that they would be able to search for alcohol. So that is the same between if they were pulling somebody over for driving while impaired by marijuana versus driving while impaired by alcohol. They would have the same effective abilities to conduct a search inside the vehicle. So nothing really changes with regard to that.
All right, thank you.
Somebody, Delegate Erican?
Mine's just a procedural question, because, when he held the bill, you suggested he should hurry and get his amendment together, but now we're hearing that we're not allowed to offer amendments. I'm just trying to understand what the rules of the order were.
I think that we had an amendment. We moved the amendment. We were on the bill. We were on discussion on the bill. We moved to that next point. And so at that point, we're moving on the bill. And so we're past the point where we were dealing with amendments, and that's what I'm ruling.
Okay, because right before when he held it, you had said, hurry and get your amendment. So I just wanted to understand, because I explained how to order amendment, all that stuff after that.
All right, I appreciate it. Delegates Grammer and then Conaway.
Thank you, Mr. Chair. So the entirety of the question of this bill, as I understand it, is the balancing of the Fourth Amendment concerns with the public safety concerns of codifying probable cause. I mean, that's the totality of the question here. And the concern I have is the story that we heard the other night, which is the same story for some reason that we always hear about this. Somebody got in a car, smoked marijuana, and drove somewhere, and we're forcing law enforcement to try and, without this probable cause, or statutorily codifying when this can be used, to kind of thread that needle. And again, I get the privacy concern, especially as states adopt adult use, but I feel there's a point which we step over with public safety where there's a better way to deal with this question of probable cause than to try and codify it. And I have a concern here because you hear the same exact story over and over. For some reason, a person had to get in a car and smoke the marijuana there, now we have all these stories about, I had to drive here. This person had so much that they could be charged with possession with intent to distribute. And I fear taking this route, we're going to reinforce that behavior. And I always believe there's a way to improve on public safety and criminal justice reform, and I'm just worried that trying to codify the probable cause here is giving me reason for concern.
Delegate Conaway.
Thank you, Mr. Chair. Before I ask my question, I'd like to say that personally, I don't really like misquotes and answers that throw me off. So as I remember, you gave 1 hour for the amendments, for anybody that had amendments to bring them in for this bill. In reference to the quality of life question, my question is, can the police officer or can someone say that you're influencing their quality of life if they're in the store and you can smell the cannabis in the next aisle over from where they are?
Are they smoking it?
No, but you can smell the odor of it.
If they were smoking it, it would be a violation of the Clean Indoor Air Act. If they're not smoking it, then no, that in fact, there's case law on point that says that they can't be stopped or searched at that point.
Thank you. My last question on this is, if a person is smoking the cannabis in their car or in a car, but the car is not moving, but they have the keys in their possession, they're sitting in the driver's seat, is that probable cause for search?
The standard for determining whether someone is driving while impaired is that they have to be in actual physical control of the vehicle. There's a case called Atkinson that says that what that requires is something more than simply sitting in the car. They have to have done something that puts them in actual physical control of the car, which would include, for example, having the keys in the car running, something more than just simply being in the car. That would be the prerequisite for being able to drive, for the driving part of driving impaired. Again, the officer under this would have to demonstrate that they knew that the person was driving under the influence of marijuana, which means they need something more to be able to say they're actually driving the vehicle and there's some indication, some indicia that they are actually impaired.
I thought that a person could be charged with a DWI if they were sitting in the car in the driver's seat with the keys in the ignition and police
If the
officer.
key was in the ignition and the car was on.
They listen to music, don't want the battery to run down. You got a high-powered stereo system in your car. So
If the engine of the car was running, yes. If the engine of the car was not running, I think it's likely that they would not be found in actual physical control of the car.
Thank you very much, Mr. Chair.
Thank you. Delegate Young, Delegate Taylor.
Thank you, Mr. Chair. And thank you, Delegate Conway, for your line of questioning, most of which is where I was going to go. Was going to start with smelling like marijuana is not a crime. Driving while smelling like marijuana should not also be a crime. I refer the committee back to my hypothetical earlier where we talked about, parts of my district, they are very small backyards, not much front yard, maybe 3 steps of a stoop. You can't smoke in your house, and we heard ambiguity whether you can smoke while walking down the street. So where can you smoke? Probably in the backseat of your car. So your car might smell like weed, and I think we need to be mindful of that for individuals. And then lastly, recognizing that, my colleagues in the back from the ACLU are back there, they have a map, a big map that I wish they would have brought in maybe, that shows you where these arrests happen. I mean, this is the pretext for many arrests in Baltimore City, and they are very, very racially motivated. I mean, maybe not racially motivated, but racially divided. It's very clear where the lines are, and if you know Baltimore and where people live based on race, it's very clear, segregated city in a significant way, and those arrests align along those very same segregated lines. So for those reasons, I'm going to be a yay vote.
Thank you. Delegate Taylor.
Thank you, Mr. Chair.
Could you pull your microphone down?
Oh, sure. Thank you, Mr. Chair. So let me know if I'm out of order here, because I know we've already moved on the amendment, right?
There was a motion on the bill and there was a favorable on the bill.
Okay, so in the amendment, Section C, which pertain to evidence discovered or obtained in violation of this section, including evidence discovered or obtained with consent, is not admissible in a trial, a hearing, or any other
That's not in the
proceeding.
amended bill.
It's no, so it was struck.
It was struck.
Okay.
Language with regard to that is in uncodified language in the bill.
Okay, and can you speak to why it was struck?
It's put in the uncodified language of the bill because when it comes to what is effectively language related to the exclusionary rule, we try very hard not to directly tell judges how to rule on specific things. And that is effectively what an exclusionary rule does.
Okay, so is it implied then?
It is
that what
meant
that
as
means?
guidance in the, and it still has force of law in the uncodified section.
Okay.
One moment. Right, so to be clear,
Sending out the correct one.
there is the version that apparently did not include the exclusionary rule. It is in section 3 of the bill that'll say that the exclusionary rule and its exceptions are, as judicially determined, applies to this act. Delegate Tolles.
Thank you, Mr. Chair. Parliamentary procedure, we were in a motion, and I think we've had a lot of discussion, so I'm going to move the previous question.
There's a motion for the previous question. All in favor of moving the previous question, say aye. Opposed, nay. Motion for the previous question is adopted. We're on the bill as amended. There's a favorable. The Vice Chair. Yes. Munoz. Yes. Crutchfield. Yes. Cardin. Yes.
I'm going to vote yes. And I just, for those of you who weren't here last year, I voted against the initial bill that we passed out of this committee last year. And one of the there were two primary reasons. One was because I don't think we have completely dealt with the DWI issue. I don't think we understand it, and technology is not there yet for it, and it concerns me. The other issue was public use and the fact that we reduced the amount, the penalty, the fines for public use. Those were essentially the two reasons I voted against it. I'm voting for this bill because I don't believe the public use decrease this year is really the essence of the bill. This is really a Fourth Amendment bill, and this Fourth Amendment issue trumps all the other issues. I really do think that we thread the needle very well with this without creating unintended consequences because of what we did with the exclusionary rule. For that reason, I'm going to support this and hope that the Senate puts the penalties back up. But if they don't, I mean, I know that you guys don't like that, but we'll see. Anyway, thank you.
Cardin is yes. Bartlett? Embry? Yes. Pasteur? Yes. Tolles? Tolles is a yes. Schmidt? Yes.
Thank you, Chair. I just want to share a personal story. Recently, about 4 weeks ago, I was the passenger in a vehicle accident where we were rear-ended by somebody who had the odor of marijuana. And so as we waited for 90 minutes for the state troopers to arrive to process the scene and take statements, they were unable to search the car. They were unable to discuss that with the person who rear-ended us. And that's in a current environment where it is illegal. And so, therefore, I am a no on this bill. Thank you.
Delegate Boucher? No. Delegate Phillips? Yes. Delegate Tomlinson? No. Delegate Arakan? No. Delegate Taylor? Yes. Delegate Simpson? Yes. Delegate Grammer? No. Delegate Young? Yes. Delegate Valentine? No. Delegate Conaway? Yes. Delegate Kaufman?
Yes, I wish to explain my vote if I may.
Go ahead.
I am voting yes in honor of my friend Delegate Taylor, who told a very moving story during the hearing that really underscored the racial overtones related to this issue. And to me, it's an issue of racial equity. So in honor of you, dear friend, I'm voting yes.
Delegate Williams?
I'm voting yes, and I'm okay with the lower penalties.
Thank you. The motion is adopted for a favorable 15. All right, thank you very much, everybody. That concludes the voting session for tonight on March the 15th. We will be back tomorrow. Thank you.